Hi, Greg.
William,
How you doing?
well, and you?
Very well, thanks.
That's good. We're the only ones here so far. Oh, there are some others there, I see, yeah.
Yeah.
Morning.
Good morning.
Morning, my lady.
Good morning.
Good morning, my lady.
Please attend and talk to us in a bit.
Good morning, my lady.
Good morning.
There's a major traffic jam on the N3 near Pietermaritzburg after a fiery collision between two trucks.
Appears that we are on some media platform. If the studio can please mute their mic. Thank you. Paul? You may call up the matter.
Good morning, my lady. Thank you. As the court pleases, my lady, this is a matter between the Special Investigating Unit and Digital Vibes, plus 36 others, case number KN03 of 2021, appearing in the Special Tribunal of South Africa before Madam Justice Modiba, 20 June 2022. My lady.
Thank you. Council may place themselves on record.
Milady, up here for the 33rd and 37th respondents. GD Harper, SC.
Thank you, Mr. Harper.
My lady, I appear for the 32nd, 34th, and 35th respondents. Nicholson, Initials WAJ.
Thank you, Mr. Nicholson.
My lady, I appear on behalf of the 36th respondent.
Thank you, Mr. Tron.
My lady, Ian Curry for the SIU with Mr. Singh.
Thank you, Mr. Curry. Okay, we may begin. The notices of appeal have set out the grounds quite elaborately, and I've benefited extremely from your comprehensive heads of argument, those parties that have filed heads. So it's not necessary for you to take me through the written submissions in detail because I have read. You may just emphasize the points that you'd like to emphasize. Thank you. Mr. Harper, are you going first?
Yes, milady, I have no objection to going first, although I'm number 33 and there is a number 32, but be that as it may, I will go first. It may be convenient. Milady, yes, thank you. I've taken note of your remarks as regards heads of argument. We did not deliver heads of argument, but we, in essence, delivered our application for leave to appeal, which contains references to authorities as well. So it is sort of a combined application for leave to appeal incorporating heads of argument. So I take it that you have read that, and I won't go through paragraph by paragraph. There are 5 points that emerge from our application for leave to appeal, and if I can just enumerate them before dealing with them in any greater detail. The first is the test for an application for leave to appeal. The second is the test for joinder. We submit that the SIU have got the wrong test, and that another court may reasonably disagree with your finding in that regard. The third point is our submission that on the correct test, SIU have no cause of action. The fourth point is that the money has been repaid in question, and there's no point in proceeding further against the 33rd and the 37th respondents. And the fifth point is that there's no constitutional remedy unless there is a recognised cause of action in the first place. So we're back to the situation of no cause of action. So if I can deal with those points in broad outline while still maintaining all of the submissions set out in our application for leave to appeal. The first point is, what is the test on an application for leave to appeal before this honourable tribunal? We submit that the test very simply is whether there are reasonable prospects of success. There has been some debate in High Court cases as regards whether the use of the word would have reasonable prospects of success in Section 17 of the Superior Courts Act implies a more onerous test or not. We submit that the better view is that the test has remained unchanged. It is whether there are reasonable prospects of success. The use of the word, quote, would in context indicates only that the future tense is involved. In other words, if the appeal were to be allowed, would it have reasonable prospects of success? So we're back to the reasonable prospects of success. There's no different test. But even if there is, we submit that this is an appeal that would have reasonable prospects of success for the reasons I now turn to. The next point is the joinder test. SIU place great reliance upon the Supreme Court of Appeal judgment in Johannesburg Society of Advocates versus Natai. With respect, they take that test out of context. The context was that the Johannesburg Society of Advocates sought leave to intervene in the Natai matter. The situation was historically that the societies of advocates had been the sole repository of the custos mores of the profession. That changed with the advent of the Legal Practice Act, and the question arose as regards whether the Johannesburg Society of Advocates had locus standi to intervene in the circumstances brought about by the new dispensation in the legal profession. The Supreme Court of Appeal held that they did, because they said that they hadn't lost their role as at least a partial custos mores of the profession, and that they were clearly an interested party in the circumstances. They had a direct and substantial interest. Now, applying that test here is inappropriate with respect, and another court may reasonably come to a different conclusion, and the reason is as follows. This is not a case where the 33rd and 37th respondents seek leave to intervene. On the contrary, they resist the joinder of them. Now, even if the Natai test did apply, it's trite law that you don't need to join a party if that party waives the right to be joined. So that applies a fortiori here, where the 33rd and 37th respondents resist the joinder. So there's no reason or no justification for joining them at the instance of the SIU. And insofar as the SIU rely on the Natai test, one only has to look at the original notice of motion. The original notice of motion is for the review and setting aside of a contract between different parties entirely from the 33rd and 37th respondents. Those 33rd and 37th respondents were never alleged to be a party to the contract in question that the SIU proposes to set aside. So absent seeking relief against the 33rd and 37th respondents for money judgment, there's no possible basis upon which it can be contended that they are interested parties in what happened in relation to a contract between completely different parties. And the SIU's reasoning leads to the absurd result that they've created a perfect defense for everyone in the matter on the basis of non-joinder. Because if the 33rd and 37th respondents way down the line are to be joined as respondents, then as I submitted previously, why not join checkers who may have got some of the money from the farm workers purchasing groceries, and the farm workers were paid if one adopts a cash flow process. So where does one join the line? The SIU, with respect, is creating a defense for parties which they should not do, because there's a non-joinder defense here. Because if you don't draw the line at the 33rd and 37th respondents, you have nothing whatsoever to do with the contract under review. Where do you join the line? If there is this eponymous principle that you can track monies, although it passes through multiple banks and multiple hands, one joins virtually everyone that one can say received money as a result of money being received by someone else further up the line. With respect, it's an absurd situation which another court reasonably could disagree with in relation to the test. The real test is this, is if you want to sue someone, you can sue someone, but you have to have a cause of action against them. So the only reason why there would be a justification for joining the 33rd and the 37th respondents is if there is a valid cause of action against them in the first place. And it's apparent that the applicable test for joinder in those circumstances, if you want to join someone, is whether there's a cause of action. Whether you look at it from the perspective of taking exception to a party's particulars of claim, or in the context of application proceedings, whether you set the matter down for argument on the basis that there's no cause of action disclosed in the application proceedings, which one can do without even lodging an affidavit. It's the same principle. It's the exception principle. Does the party wanting to join me have a cause of action against me? And if the answer is no, then the party should not be joined. So in those circumstances, we go back to our submission that the correct test is whether they have a valid cause of action. So that then brings us to the next point. Do they have a valid cause of action? The only cause of action that they rely on is an enrichment cause of action. They say that these condictio ob terpum causam, or the condictio in debiti, or the condictio sine causa, the latter two are recent additions in the argument according to my recollection. But with respect, none of them sustain any scrutiny at all, because they fall down at the first hurdle. And the first hurdle is this, is has the party receiving the money received the money from the party claiming to be impoverished? Because an enrichment action only lies to help a party who claims to be impoverished because he has paid his money to another party, and that other party has been unjustly enriched. So the SIU now, in their representative type quasi-capacity, say, well, the government's been impoverished and the 33rd and the 37th respondents have been enriched because they have received a portion of the money that flowed from this contract that we want to set aside, and it doesn't matter that they're down the line. The SIU says it doesn't matter that the money has passed through multiple banks. It's still the same money, and you can recover it from the 33rd and the 37th respondents on an enrichment basis. None of this has any basis in law whatsoever. The commixtio principle and the commixtio defense applies. The 33rd and the 37th respondents did not receive money from the government. I want to repeat that with the utmost respect. They did not receive money from the government. They received it from a bank, and the bank was Mateta's bank. They did not receive it from the government. So the money simply is not reclaimable at the instance of the SIU, because the money that was received by the 33rd and the 37th respondents did not come from the government. It came from someone else. And that really is the end of the case. And with respect, another court reasonably would come to that conclusion for the simple reason that that's the law. So that's the third point. The fourth point is that the money has been repaid. If there was any notional basis for an enrichment, with which respect there isn't, the money has been repaid. It doesn't matter where the money came from, because the principle of commixtia applies the other way as well. SIU make a vain attempt in reply, which is impermissible because they must make their case in founding, for the notion that somehow the money that was repaid to them came from the 150 million. Firstly, there's not a tittle of evidence in that regard. It's nothing other than sheer speculation by the SIU. Secondly, even if it did come from portion of the monies, it doesn't matter, because again, the money can't be traced the other way either. Once money is paid to a bank, it becomes the property of the bank. It's no one else's money but the bank. So on that basis too, the SIU has no defense whatsoever. They also try and raise an argument that, well, it's only been repaid to them on a conditional basis, and it may be that they have to repay some of the money to the person to whom the person from whom the money was repaid. Now, again, that is self-destructive, because if there's a legitimate basis for them to repay the money to that person, they weren't entitled to it in the first place. So their argument there with respect is absolutely circular and has no basis, and another court may reasonably find that. The fifth point is whether there's some constitutional remedy at large which would provide a cause of action to the SIU, even where there is no recognized cause of action according to the common law or statute. And the answer to that is no. There's not some type of just and equitable principle where if a judge thinks that it's fair in the circumstances there should be a remedy, that there is a remedy. That is intended only to act as a foundation for remedial action if there is a recognized cause of action, which there isn't. So we're back now to the situation of no cause of action whatsoever. And if I'm wrong in that regard, that there is some type of novel, constitutional remedy at large, which exists independently of the penumbra of the normal common law and statutory remedies, then it's undoubtedly a matter that deserves the attention of a higher court. Because there's undoubtedly an argument here to say, whatever the intention in some slight wording in the constitutional to create a remedy in relation to setting aside unlawful contracts, that you can recover the money from anyone remotely said to have received monies as a result of this cash flow. That would be a novel and, with respect, a breathtaking proposition that requires to be pronounced upon by the highest court. And it would certainly justify the grounds for an application for leave to appeal on the court, that another court may reasonably disagree with that proposition. So, my lady, those are my 5 points in the matter, and my respectful submission remains, with the greatest respect to yourself. In a complex matter such as this, there is a reasonable prospect that another court may reasonably disagree. The final point I should perhaps mention, it has been mentioned in our heads of argument, is the question of costs. We respectfully submit that even if Joinder were to have been granted, the cost order is inappropriate in the circumstances, because in effect it acts as a prejudgment of the ultimate merits. And the 33rd and 37th respondents have been mulcted in costs, when on any basis that is a situation, if the logic of Milady's judgment is to be followed, that should have been dealt with by the trial court. So in those circumstances, we respectfully maintain that an appeal has reasonable prospects of success, and humbly pray for leave to appeal, with costs to be costs in the appeal.
Thank you, Mr. Trump.
My lady, I align myself with the argument that Mr. Harper made, and I won't repeat it. I agreed with his argument in toto, except maybe that I contend without finessing the test that another court will come to a different conclusion. My lady, if I may, perhaps just read one portion of a judgment to your ladyship, and that is quoted in my heads of argument. It is the judgment of YST Properties. At paragraph 45, the court says the following: on a close examination of the authorities referred to above, it is clear that payment made under protest is not conditional and constitutes full payment of the debt owed. It is up to the person paying to establish in other proceedings that the amount paid was not actually owing and that it should be repaid. It was submitted correctly on behalf of the applicant that until a court makes such a finding in favor of the person paying, the party paid is in exactly the same position as any other person who receives money in discharge of a debt. So the finding that your ladyship made that the payment is somehow conditional is simply wrong in law. The judgment in YST followed the Supreme Court of Appeal. I referred your ladyship to that judgment also in the footnote in my heads of argument. So it's been paid. There can't be any question of any enrichment action. Any enrichment action that may have existed up to that point of payment is now dead. There is no cause of action against the 36th respondent or any other party that received money from Mateta or Cirela. So, my lady, with respect, the conviction is completely dead in the water. I uploaded this morning a judgment, and I tried to send it. I sent it to the wrong counsel. I thought Mr. Roux was still leading the SIU team. And if my learned friend, Mr. Curry, needs to deal with this in supplementary heads, I have no objection to it. It's the judgment of Leal and Company versus Williams, 1906 TS 554. I've uploaded it to the case lines, to the next number on case line, so that your ladyship can have access to it. It is my respectful submission, my lady, that where money was paid in this instance from Mateta to Cirela and from Cirela to Itala Bank, the money went through at least 2 different banks, potentially 3 different banks. Mr. Harper is correct. The money became the property of those respective banks, and there was a concomitant personal right of the account holder to the debits and credits as it so happened. So, with the greatest of respect, there's 2 levels of commixture, and there is simply no way that a conviction can find its way through that path. Mr. Harper is correct that a conviction works between immediate parties. It doesn't work for the further party. And if your ladyship has regard to Leal and Company versus Williams, it's the court of the Transvaal Provincial Division, and it's still good law. It's a judgment by Innes, Wessels, and Kaluas, who held that conversion is not part of South African law. You can't follow the product of the thing that got stolen or paid down the line. You can't go to Checkers. You can't go with respect to Cedar Falls for the same reason. The conversion is not part of the South African law. There is simply no such cause of action. And there I agree with Mr. Harper. As far as the constitutional remedy is concerned, the remedy lies between the direct contractual parties. It doesn't lie to somebody who may have received further payment, and it would indeed be astounding, as Mr. Harper said, if that is the proposition. My lady, I've included in my heads of argument a section that your ladyship would have recognized, dealing with whether we in fact need leave to appeal from your ladyship. I'm not abandoning it. Your ladyship must take it as argued. Your ladyship has had it, seen it, and my learned friend can respond to it if he wants to. My lady, in the circumstances, those are my submissions.
You are not counsel for your clients in the main proceedings. You only
no, my lady. My predecessor has become indisposed. He had a groin injury, yes. So I'm clearly a replacement. Your ladyship would have seen in my heads of argument that I aligned myself with Mr. Paminter's heads of argument, In the main, it's the same as what Mr. Harper argued today. There may be some nuance differences, but I'm not abandoning those heads. I agree with them as it so happens.
Yes, I just want to find out if you had regard to the authority in Perry that I referred to in footnote number 7 of my judgment,
Yes.
and the extent to which it's distinguishable from the judgments you are referring me to, because Perry is actually an appellate division as it then was judgment.
Yes, my lady. But in this case, there is simply no allegation that Cedar Falls is guilty of any malfeasance, none at all. So it is a different position from Perry, my lady. With respect, and in circumstances where there was payment, as Mr. Harper says, that's the end of the matter.
Now, regarding Cedar Falls, Mr. Brown, I touched on this very briefly in the judgment in paragraph 54, where I referred to the SIU's request for discovery in terms of Rule 3512 and Cedar Falls's response. No, it was Cyril and Tusokuhle that responded, but effectively, it's Cirela Trading and Tusokuhle that responded to that. And the SIU, based on their response, which came late, shortly before the hearing, obviously the SIU was not able to supplement its papers, but I was addressed on how the SIU intends dealing with those responses, and that points to the possibility of turpitude on the part of Cedar Falls.
Well, that's still speculation. You have nothing in front of you that says that. And Plascon Evans still applies. If that was the situation, then they should have asked for a reference to evidence.
But we're not there yet. They've got to be joined.
No, in this application. In the Joinder application, there's simply no indication of turpitude. And they must make their case for our Joinder now, not join us and then perhaps make a case. That's not how it works. They must make their case for Joinder now. They must set out a course of action now, and they haven't. And in circumstances where they haven't shown the turpitude now,
I'm trying to explain to you why it would not have been made in the founding affidavit, because then this information was only discovered much later in the proceedings.
My lady, they've got procedural remedies. They could have asked for a reference to evidence. They didn't. They chose to argue on the papers.
Okay. Anything further?
No, my lady.
Thank you. Thank you. Who's next? Mr. Nichols, are you going to come next?
My lady, once again, I align myself with the arguments of Mr. Harper and Mr. Theron. There's just one issue in both the arguments that we may differ from, but it's not material. The issue that we are dealing with here is not money, but credit. And this complicates the case for the SIU even further in these civil proceedings. What needs to be restored to the department or to the SIU or to the applicant is an equivalent value of the credit, a monetary equivalent value of the credit, not the money. So other than that, I align myself with the argument. My lady, taking a lead from a ladyship, I'm not going to go in depth into my heads of arguments that are before a ladyship. I'm just going to summarize my heads of arguments. The issue that we seek leave to appeal upon and listed at paragraphs 1 and 2 of the heads of arguments. In effect, my lady, A leave to appeal is sought against the cost order made against the 32nd, 34th, and 35th respondents regarding the cost of the condonation application. The cost order made against the 34th respondents in circumstances where the 34th respondents was successful in opposing the joinder, and the order confirming the joinder of the 32nd and 35th respondents.
Mr. Nichols, why are you saying there's a cost order against the 34th respondent?
Milady, that starts with...
That order carefully. Could it be perhaps reference to the word proposed respondents and comparing that reference? Is that it's not a party? So clearly that order is not enforceable against the 34th respondent. He wasn't joined. He's not a party.
But anyway, the way we...
So if there's an ambiguity, it can be corrected in terms of the Uniform Rule 42. It can be corrected if you think that created an ambiguity. But clearly that cost order is not enforceable against the 34th respondent.
I'm just making a note. Yeah, ladyship on that point. The lady at paragraphs 4 and 5, we deal with the issue that despite this being a joinder application, despite this being an interlocutory application, it is appealable. And we offer the citation as ready by Minister of Law and Order. We also make the proposition that this matter is ripe for appeal and in the interest of justice. And we offer 3 authorities for that. Milady, if one now the appeal against the joinder, Milady, is dealt with in paragraph 16.1 to 16.10 of the heads of argument. There, Milady, the point is made that the full extent of the claim against the 32nd respondent is 1,090,000. The full extent of the claim against the 35th respondent is 650,098 rand. The fact is, Milady, the 32nd and 35th respondents were paid by the 18th respondent Mateta projects. The applicant has claimed the sum of 10,636,575 and 82. 10 million includes the amount paid to the 2nd and 35th respondents. Umduduzi Welcome Mthethwa, the 26th respondent, has paid back 11 million, which includes the 10,636,575 rand, which were paid.
Excuse me, Mr. Nichols. Mr. Harper, may I ask that you lower your screen? You reduce your screen. I can see that you're still screening. There's a page that you're screening. I think it's the notice of appeal.
Yes, sorry, Milady, I wasn't aware that I was screen sharing anything.
No, that's fine. That's fine. You may proceed, Mr. Nichols.
Milady, we see that at page 7 of the notice of motion, at 001, page 21 of the record. It is equally understandable fact that Umduduzi Welcome Mthethwa, the 26 respondents, has paid this amount, which includes the amount paid to Mateta by Digital Vibes. Milady, in the circumstances, Milady, with submission, the only issue remaining for determination by the tribunal is whether legitimate services were rendered by Mateta, which entitles it to repayment of a portion of the sum of 10,636,575.82. This determination will be made by the tribunal when addressing the issue of just and equitable relief. The point is that Mateta has repaid the 10 million. This cannot be increased to a greater amount by reason that the 32nd, the 32nd, 30, and 35th respondents received part of the money. At paragraph 16.7, we also make the point, my lady, that this is credit that needs to be restored, not money, which then takes the point made by Mr. Harper and Mr. Teran, which goes with the point made by Mr. Harper and Mr. Teran, that this credit went from Digital Vibes, it went to Mateta, and then it went to a number of other people. And it's that credit equivalent that must be repaid to the applicant. It's also important to note, my lady, that Mr. Mtetwa is liable jointly and severally, not Mateta. The money from the money received by the 32nd and 35th respondents were received by Mateta. So there is no cause of action between between the 32nd and 35th respondents and the applicant. At paragraph 16.9, we respectfully submit that a further material misdirection is that the applicant and the Honorable Court are using these proceedings in order to attribute some kind of personal accountability or liability to the 32nd and 35th respondents for being unjustifiably enriched. This submission is made considering paragraph 48 of the judgment. The Honorable Judge points out that the applicant contends that Mateta made the repayments in order to avoid further inquiry into the flow of the funds to the proposed respondents. It is respectfully submitted, my lady, it is not within the powers or function of this tribunal to take action against Mateta or the proposed respondents for disguising the flows, the flow of funds, because that is a domain for a different court altogether. It is further respectfully submitted that the Honorable Court misconstrued the powers of the tribunal on review when stating in paragraph 51 of the judgment that the following stands to be determined in review: whether the repayment by Mateta absolves the proposed respondents from liability, whether the proposed respondents received the payment in the ordinary course of business, whether the proposed respondents are innocent. It is respectfully submitted that those questions do not take the inquiry as to whether or not the impugned contract was legal, or whether this contract, or whether the contract value or part thereof stands to be repaid, and by whom. And thereafter to utilize the power to make a just and equitable decision in terms of section 172, subsection 1, subsection B of the Constitution. We provide three authorities at paragraph 16.10 for those propositions. Already in paragraph 15.3 of the judgment, the Honorable Judge states that none of the proposed respondents have repaid Mateta the amount received from it. It is respectfully submitted that this is a misdirection because it makes no difference for the purposes of these proceedings. And I stress, my lady, these proceedings, who personally pays the monetary value. It is not the purpose of these proceedings to join respondents in order to punish them or to exact some kind of liability from them. At paragraph 18, my lady, this Honorable Judge did not address the points made by the 32nd and 35th respondents that the applicant's powers to recover losses by state institutions extends no further than recovering losses incurred in relation to the irregularities and or corruption in the contracting and procurement process. In light of the failure by the Honorable Judge to address this issue, which was raised in the 32nd and 35th respondents' heads of arguments opposing the Joinder application, a court will be entitled to consider this issue afresh. The Honorable Judge further failed to adequately address the points made by the 32nd and 35th respondents in the heads of arguments opposing the Joinder application at paragraphs 12 to 14 that the power of the tribunal are limited to correcting or reversing the improper administrative function and determining a just and equitable relief. Milady, that is the gist of our arguments. What we seek, Milady, what we say, Milady, is that a successful appeal will absolve the 32nd and 35th respondents from those proceedings. In the circumstances, leave to appeal ought to be granted to the full court, and the cost be the cost of the appeal.
Thank you. Thank you, Mr. Nichols.
Thank you.
Mr. Curry.
Thank you, my lady. My lady, with regard to the 34th respondent, we don't read there to be any ambiguity in the order at all. But if there is any question of ambiguity as to whether the 34th respondent is liable for the costs, the SIU will not be seeking costs as against the 34th respondent. And there'd be no objection if the court was to clarify this in the judgment in respect of leave to appeal. So certainly our understanding and our reading of the order is that the order of costs does not include the 34th respondent because they are not a proposed respondent. They were not added as a respondent or joined as a respondent in the matter. My lady, the applicants are all seeking leave to appeal against the orders joining them as respondents, and that's Order 2 of your ladyship's order. Paragraph 3 of the order then further goes on to allow the amendment of the notice of motion, and the effect of the amended Order 3 is that the joined respondents, having been joined, are now the subject of a prayer that they must repay to the NDOH the specific sums that appear next to their name in the columns, for which they are liable jointly and severally with the first to fourth respondents, being Digital Vibes, and the directors and controllers of Digital Vibes, and the 26th respondent, that's Mr. Mduum Tetwa. And that, my lady, that claim.
They're also appealing the cost order, aren't they?
Yes, they are appealing the cost order, yes. This claim, which now was granted by the tribunal in paragraph 3, is the reason why the SIU sought to join them as necessary respondents. Very simply, you can't claim money from someone in an action or application unless you join them. You can't obtain or enforce the order that they must pay the money unless you first join them. And that very simply was the reason, the fundamental necessity and reason for the Joinder application. And the consequence of the granting of that order is that they now join some 15 other respondents who are in a similar position, and from which the SIU also claims repayment jointly and severally with what I could call the main perpetrators of the fraud. The claims are for specific sums of money that they received that stem from the payments that were made to Digital Vibes in terms of the impugned contracts. And my lady, it's the SIU's case that those Digital Vibes contracts, and as a consequence, the payments made by them, were procured by fraud and were unlawful and unconstitutional and must be set aside. If they are set aside, there is no causa for the payments that are made to Digital Vibes, and there's no right to retain them where they were obtained gratuitously and with knowledge of the unlawfulness of the source of funds. That is sought on the basis of the principle that we understand to have been established in First National Bank versus Perry.
Mr. Curry.
Yes.
I've not looked at the founding affidavit again in preparation.
Yes.
These proceedings, but my recollection is that the SIU cause of action is not based on fraud. It's based on abuse of authority by Minister Mkhize and his role in the awarding of the contracts and the subsequent flow of the money from Digital Vibes to members of his family and those associated with him. You're now making reference to fraud.
Yes, I think that argument is made and justified in the supplementary affidavit. It isn't in the founding affidavit, but it is in the supplementary affidavit. In other words, based on the subsequent evidence uncovered, particularly, my lady, the extent of the flow of funds to the Mkhize family. And on the basis of that, the allegation is that the first to fourth and the 26th respondent are jointly responsible for a fraud committed against the NDOH. That case is made in the supplementary affidavit.
Do you have the reference?
Not at my fingertips, but I will ask Mr. Singh to find it.
Okay. Thank you.
The fundamental case, though, as regards these, call them the additional respondents, and the joined respondents find themselves in the same position as a result of the joinder, that what's being asked for them is the repayment of specific sums of money that they received stemming from the payments, the unlawful payments made to Digital Vibes, is sought on the basis of the principle in FNB versus Perry, which we understand to be as follows, and FNB versus Perry quotes the digest as follows: the condictio obturpum, grounded in the idea of what is good and fair, has become the means of reclaiming whatever belonging to one in the absence of good cause is found in the hands of another. FNB versus Perry also establishes that turpitude by the person in whose hands the payment is found is not necessary, but what is required is knowledge of the turpitude. In other words, once you are informed about the impugned or the turpid origins of the funds, then you have no right to retain them. Once you know where it comes from and the unlawful source of it, you have no right to retain it. That's our understanding of the principle that's established in FNB versus Perry. Now, there's a long road to go in respect of that claim, but the first necessary step is to join the persons who are being claimed against, and that is simply the stage this is the stage of the proceedings at which we currently are. Moreover, my lady, the respondents from whom specific sums of money are claimed are not the only recipients of funds from Digital Vibes directly or indirectly. As Mr. Harper says, you could go much further than this. They may It's a trite principle that a plaintiff or applicant can cite the party of their choice among a number of joint wrongdoers. If there's a number of joint doers, the applicant can choose who to target. And that is the answer to the checkers proposition that was put by Mr. Harper. There's no defense of non-joinder simply because the SIU has chosen to cite and to claim against certain respondents against which it believes it has evidence that they received